Hello and welcome to this webinar on complex applications in the Court of Protection, practical tips and guidance. My name is Helen Forster and I'm a specialist in private client and mental capacity work. And what I'm going to be talking to you about today isn't the standard applications for the appointment of a deputy, which of course for property and financial affairs is now done via an online application. This is actually to do with still if we call it the more old school paper-based applications and are a little bit more out of the box. So today we're going to be talking about things such as statutory wills, equity release, those sorts of things, and the processes involved in making those applications. By way of an overview, if we start at the beginning and talk about the statutory will, in terms of the more complex applications that we deal with, I think this would be your most common application. And that is because when we are acting as an attorney or deputy under things like the Mental Capacity Act 2005, we must act in somebody's best interests. And very specifically, we are asked for, certainly when we're being appointed as a deputy, details of someone's will. And that is because, of course, acting in someone's best interest, we need to look at what they ultimately wanted to happen with their assets. And within reason, we need to try and make that happen. Of course, with things like paying for care, etc., it might be that some things have abated and gone, but we need to take into account what those wishes are and essentially work backwards.